Hello, everyone. Today, I'm here to discuss a significant immigration update that affects many aspiring specialty occupation workers and their employers in the United States, the H-1B Modernization Rule. This new rule issued by USCIS brings both clarity and some challenges to the H-1B visa process. My name is Ingrid Perez. I'm an immigration attorney. If this information is valuable to you, please subscribe to my channel and turn on your notifications so you can get more updates about immigration topics that apply to you. The H-1B visa category is designed for positions that demand a high level of specialized knowledge, typically requiring at least a bachelor's degree or higher in a specific field. It's a key pathway for many foreign professionals seeking to work in the U.S. and for U.S. employers wishing to fill gaps in their workforce with specialized talent from abroad. The new H-1B rule went into effect on January 17, 2025, and U.S. employers have always been prohibited from hiring an H-1B worker at a wage or under working conditions less favorable to those similarly situated U.S. workers. So if you're hearing all this talk about H-1B visa holders replacing U.S. workers, that is not true. That's not to say that there aren't abuses of the program and maybe problems, and this is what this new rule is meant to address. It codifies long-standing practices to strengthen program integrity, providing some reassurances for both employers and employees. So for example, the new rule expands the cap gap for F1 students. So in the past, an F1 student who was the beneficiary of a timely filed H-1B petition that included a request to change status to H-1B would get a continuation of their F1 status and any applicable work authorization until October 1st, the start of the fiscal year and the earliest start date for the cap subject H-1B petition. But because of processing delays, many H-1B petitions weren't adjudicated by October 1st. So this new rule extends the cap gap coverage until a potential maximum April 1st of the fiscal year, which is a great update for this category. In this new rule, USCIS is using a new definition that says the degree has to be directly related, which means it has to have a logical connection between the required degree or its equivalent and the duties of the position. So USCIS explains in the regulation that there could be a range of qualifying fields if each field is directly related to the duties of the position. They also said that they're not focusing on degree titles so much and will consider whether the person's actual course of study is directly related to the duties of the position, which is really a great change. Another critical change is the introduction of a rule to give deference to prior approvals of H-1B workers when they're seeking extensions or changes, unless there's a serious error or change. And this specific change is a direct counter to the practices seen in the first Trump administration, which had rescinded a similar policy, and it led to a lot of delays and increased scrutiny. And if you're wondering what will happen to this now that Trump is back in office, you're going to be happy to know that these rules are here to stay. And while these rules offer some clarity and improvements in several areas, of course, it's not without its critics. There's a lot of concern regarding how some of these changes will be implemented in practice. For example, the broader definition of specialty occupation can still leave some room for interpretation, leading to inconsistency in petition approvals and denials. The emphasis of the program is also integrity, which introduces documentation and evidence requirements that could pose lots of hurdles to employers, especially smaller businesses, in showing that they need H-1B workers. And the modernization rule introduces a much more nuanced approach to the H-1B visa process. It's aiming for a balance between flexibility for employers and protection for U.S. and H-1B workers. And as with any major change, the real-world impact is going to unfold over time. So it's really important for any H-1B applicant and their employers to stay informed and prepare for a more complex application process. The H-1B Modernization Rule represented a significant shift in immigration policy under the Trump administration. It reflected a move towards a more nuanced, potentially supportive measures for foreign workers and their employers. As an immigration attorney, it is my job to navigate these changes and making sure that the benefits of these modernizations can be fully realized by everybody we serve. If you have questions about the H-1B process or need help filing your H-1B petitions, use the link in my bio, go to my website, and my office is ready to help.